All rise. The Honorable Justices of the Supreme Court of the State of Iowa, hear ye, hear ye. The Honorable Supreme Court of the State of Iowa is now in session.
Everyone, please be seated. Well, this is what we call night court. We only do this once a year, and it has a different feel to it. So thank you, everyone, for taking time out of your evening to come and watch a case with the Iowa Supreme Court. Tonight, we are having the case of Burnett versus Philip Smith and State of Iowa, and it looks to me like the parties are ready, so we will go ahead and begin with Mr. Diaz.
May it please the court, counsel. This case is a false arrest case against the state of Iowa. The problem for the plaintiff is that false arrest claims under Chapter 669 are not permitted. That's a legislative decision. So if this plaintiff is to have any remedy, it must come from something greater than the legislature, in this case, from the Iowa Constitution. If this court concludes that he's not entitled to such a remedy, then all Iowans would be without a remedy for a false arrest. The facts of the case are very simple. Mr. Burnett is a commercial truck driver. He was operating a garbage truck. He was pulled over by a motor vehicle enforcement officer, for a cracked windshield. There was clearly probable cause to pull over that vehicle. The officer requested the opportunity to inspect, which he has that right to do. And as part of that, he asked Mr. Burnett to assist him in performing the inspection. Mr. Burnett declined. He refused. He said, no, if you want to inspect it, have at it. I'm not going to stop you from inspecting it, but I'm not going to assist you in doing so. A back and forth occurred between the officer and Mr. Burnett. And eventually, Mr. Burnett was placed under arrest for interference with official acts under Iowa Code Section 719.1. After he was arrested, Officer Smith was able to complete the inspection. Iowa Code Section 719.1 allows an arrest where an individual either resists or obstructs an official act. In this case, the resistance was passive. The Iowa case law indicates and requires that any so-called resistance or obstruction be active, meaning something more than simply saying, I'm not going to help you with this inspection. For example, if Mr. Burnett refused to provide the keys, locked the officer out of the vehicle, that would be an example of active interference. In this case, it was none of that. There was nothing that prevented the officer from completing the inspection and, in fact, was able to complete that inspection.
I have a question for you about the scope of relief under the Godfrey claim. So I understand your argument about not having redress. And I guess one is, why is it necessary that the state itself be a defendant versus this particular officer?
As you know, in this case, both are defendants. I brought a claim against it. My understanding is that we've applied the concept of qualified immunity to not only the officer, but the discussion has been that a qualified immunity will also be provided to the municipality or the state. If they're going to be judged by the qualified immunity standard, it seems to me they ought to be responsible for him. So I don't know if that's...
The state cannot assert a sovereign immunity defense or doesn't have sovereign immunity with respect to a Godfrey claim?
I think it would have to because the sovereign immunity that they waived under Chapter 669 had exceptions, one of those being the false arrest exception. And so therefore, to that extent, they have asserted, the state has asserted sovereign immunity. But can the state assert sovereign immunity from constitutional violations? And I think the answer has to be no, they cannot. Otherwise, what's the point of having a constitution if you're not going to be able to enforce that constitution?
You've tried claims under 42 U.S.C. 1983, and there's that whole elaborate fiction that you sue the officer in their individual capacity, even though they're on duty, they're acting in the scope of their employment. We haven't adopted that under Godfrey, have we?
And if you went, because the only other route that this Mr. Burnett would have would be under Section 1983 to assert a claim under the U.S. Code. The problem there is that this court has said, we're not going to follow the Harlow version of qualified immunity under that because we believe that we have, under the Iowa Constitution, the opportunity to develop our own standard or burden of proof.
Be better to try to challenge the immunity itself in the Iowa Tort Claims Act to assert the common law claims versus creating this fictional constitutional tort. It seems like that's more consistent with our history.
I know that you've made that, I think you've made that point before in other oral arguments, and the problem I have with that is we're basically relegating the Iowa Constitution to sort of this window dressing. I mean, either we have that ability to assert a claim for damages under the Iowa Constitution, or we're going to say it's only a defensive mechanism available to us.
Constitution. Let's talk about Article 3, Section 1, separation of powers. It says that no person exercising one of these functions shall exercise the function delegated to any other branch of government. And then Article 3, Section 24 says the legislature is responsible for spending. So if the legislature refuses to recognize the Godfrey claim, how can the court require them to pay a damages claim for it?
We've done that in other instances, obviously at the common law level. We require the state to pay any claim under Chapter 669, for example. But more importantly, there's the concept of separation of powers is restricted by the fact that the judiciary ultimately determines the scope of the Iowa Constitution. So I think you can do exactly that and still hold a municipality or the state responsible for that.
I guess I'm having trouble squaring that. So you want to create an implied cause of action that allows the judicial branch to require the legislature to appropriate money to pay for a tort claim when the text of the Constitution says that that's impermissible unless, in its language says, quote, expressly provided by this Constitution.
Let me ask it this way. First of all, I think the court has said in Godfrey that we're going to recognize constitutional tort claims.
Square that. I understand the part about the suit against the officer, but the suit against the state itself as an entity, if the state says, we don't recognize this constitutional tort, we're not going to pay for constitutional tort claims, then what's the constitutional authority to compel the state to do that?
The authority then, under that reading, what's the authority of the legislature, of the court to demand that the legislature provide funding for the judiciary? Under that thinking, wouldn't you be able to say, sorry, we're going to give you zero for this year?
Another set of examples. Even before the Iowa Tort Claims Act, long line of precedents that when the state of Iowa entered into a contract with somebody, that contract had to be honored by the state and they could be subject to damages, just as they are today, whether the legislature appropriated money or not, right?
Respect to proprietary functions of government. I mean, there is a long line of cases that says when the government acts like a citizen and makes a contract, then it can be sued. And there's another line of cases that says no estoppel, no latches, no unjust enrichment, no claims against the state in its government function without its authority or consent, right?
Well, we're having a back and forth here on a subject matter that I'm not as familiar as you are on this issue. All I can indicate to you is that the accountability has to be more than just the individual officer. It has to be that entity that is sending that individual out, no different than in a respondeat superior setting. If there are going to be restrictions in the Constitution, that's for the court to ultimately make the call on that.
I mean, Bivens doesn't do that.
Bivens doesn't utilize, well,
Action against an officer, not against the United States government. So Godfrey is broader than Bivens in that it pierces the government entity's immunity.
and my recollection of the Godfrey decision is they talked in terms of Bivens and utilized Bivens as sort of a framework, recognizing that Bivens has its limitations in terms of, since Bivens. So I think the court was well aware of that at the time. So I'm not sure where, how I can respond to that other than that this court has indicated that this is what we're going to do with Godfrey-type claims. And whatever limitation you want to put, that's ultimately the seven of you get to make that call. All I'm saying is that it doesn't make sense to have only the individual be responsible for it. Why wouldn't the employer that sends them out, trains them, and does all of the other things, why wouldn't they be accountable as well?
I switched to kind of a technical point. The district court, in its ruling, granted summary judgment separately on punitive damages. You haven't appealed that, as far as I can tell, have you?
We're limiting it to the constitutional claim alone.
Appeal is successful, it would be, the case would go back only on actual damages, is that right? Okay.
You started out by saying that this is a false arrest case. How do the elements of the constitutional claim that you're asserting differ, or are they the same as a false arrest case?
I thought that constitutional claims are sort of on a different tact, and I think I made that argument in the White case when I was here a little while ago. The standard of the elements that I laid out then, and I'll restate them, is that the standard is that you have to have action by a government official within the scope of their official duties that result in a denial or interference with that person's constitutional right. That language comes from actually from 670, the use of that by the legislature in 670. And then the constitutional right has to fall into one of the categories: property rights, liberty, due process, and privacy rights.
That to a jury.
Exactly the way I've indicated here. This is how you do it. It's, I think I've indicated in the White case when we did oral argument then that I think there has to be a threshold on the part of the court to determine whether or not the constitutional right exists, and whether or not there's sufficient evidence to submit to the jury the issue of denial or interference. So I think that's how you would instruct, would be along those lines.
The right to the jury, or you're just going to let the jury just liberty and just...
Describe that right based on...
So how would you describe this particular right that you're talking about?
Not to be arrested without probable cause.
Okay, so...
And then, depending on the case, it might be a fact question about whether or not probable cause exists, or it may have been resolved by summary judgment, ahead of time. As in this case, I've taken a position that, as a matter of law, there was no interference with official acts, and therefore there was no probable cause. And I don't know if I'm responding to your question or not, but that's how I would approach it.
To some extent, I'm just then trying to think about how that compares into a false arrest claim.
There's only two elements in a false arrest claim. Either you have a detention and something that's unlawful. So the way you would instruct a jury there is to describe the elements of what constitutes deprivation and what constitutes unlawfulness. And to some degree, again, it has to be resolved pre-trial in terms of whether or not the plaintiff has made out a potential case.
Detention different than what you've just described as arrest without probable cause?
So I don't think so, but I mean, in my viewpoint, probable cause is sort of the standard, and you know, you can develop language that outlines for a jury what probable cause constitutes.
Was not an exception under the Iowa Tort Claims Act, would you have a claim?
What, I'm sorry, if,
Not an exception under 669-14-4, would you still have a constitutional claim?
but I think it's, I think it becomes more relevant in other situations. Like tomorrow morning, I'm going to be here on malicious prosecution. I think there's a great example where I think that the elements ought to be different than the elements that are set out, you know, to that regard. But I think for a false arrest claim, effectively, you're going to be, you know, similar. The difference, as I pointed out when I was here on the White case, is, and I'm about out of time, is, and now, of course, now it's 7 o'clock or whatever, and the brain isn't working as well.
Oh, yeah, the elements there, what you're going to argue.
I'm sorry, I've lost my train of thought on that. I apologize.
Can I,
Don't worry, we got more for you. Go ahead. And yeah, even though you're beyond time, you get to stay.
Do a follow-up on what Justice Oxley was asking you. So just as a practical matter, we haven't had many of these cases go to trial, I don't think, on the constitutional claim. So how would this work in practice when you have an Article I, Section 8 claim, and let's say you have a motion to suppress in a criminal case, and the defendant wins, and there's a finding of a violation of a constitutional right? Is that res judicata then on a follow-up civil suit for that same defendant?
On who the parties are, and I think that was sort of one of the issues that gets popped up in this case, is if the court deems that the prosecution, the state of Iowa, is the equivalent of the individual that caused the act. For example, in this case, Officer Smith was the only witness at the trial. So I don't think it's necessarily res judicata, but I think there may be instances where it could apply. And I remember what I thought about, which is that my viewpoint is that common law claims are very different than constitutional claims, because constitutional claims, you're vindicating the right for everyone. Common law claims, you're just asserting a right for yourself.
just seeking damages for yourself? Correct. One follow-up to that then is, in Godfrey, one of the things that we said was that you have a damages claim if you don't have an adequate remedy otherwise. And so, but for the exception in 669-14 for false arrest, so in your view, false arrest would not be an adequate remedy to protect those rights under Article 1, Section 8?
Well, I think the adequate remedy requirement under Godfrey shouldn't be there. But, I mean, obviously, we would follow that. But clearly in this case, there's no adequate remedy for him under Iowa law.
To just get rid of that exception, would that then give you an adequate remedy under the Godfrey framework?
I would do whatever I can with whatever you give me, Your Honor. Thank you.
Right, the court is aware we didn't get the clock going immediately. So, Ms. Register, we will make sure that if you need an additional couple minutes or whatever, we won't cut you off. So, you bet. Thank you.
May it please the court, counsel. Good evening. My name is Tessa Register, and I'm here with my colleague BJ Tarones, and we represent Officer Smith in the state of Iowa. I want to start with the principle that being asked to show that not only your systems work, but that you can safely operate them is not assisting an inspection, that is being inspected. And so I want to talk about kind of where we are in the law here. The DOT can stop any commercial vehicle if they have a reasonable cause. That's the A1 disposal case. And here, Officer Smith observed a fairly sizable crack in a commercial vehicle's windshield. And so he observed a vehicle that was in visible disrepair. And so he pulled it over to conduct an inspection. And he performed what's called a level 2 inspection. And so there's no dispute in this case that the stop was good, the ability to conduct the inspection is valid, and a level 2 inspection is lawful. And that level 2 inspection is important because it's both the safety of the driver and the vehicle. It's inspecting both. And if you look at page 29 of the appendix, that shows the actual report, and there's a section up top that talks about the driver portion of the inspection. And there's spots there to indicate, did you test for alcohol? Yes or no? And if you did test, what was the result? Did you search for drugs? Yes or no? And so that tells me that observing the driver is part of the inquiry. A vehicle is only as safe as the person driving it. And so because...
Statute. That's, I mean, we're talking, to me, there's so many other examples that you could maybe give, but in this case, I think I agree with you. Getting up to the point of pulling him over, calling, this is an inspection, I can't imagine having much disagreement with that. I am having a hard time with the rest of that argument. I'm thinking of, for example, field sobriety test. Of course, you got to move your body. You have got to participate. It's not going to work. That's not true with the inspection. Help me understand, where is the requirement language, the obligatory, you got to help me do this?
That's coming from the fact that this is a level 2 inspection, and the inspection is a walk-around inspection. That's where I'm getting that requirement.
The statute doesn't sound like that.
Go into the levels of inspection, but what our scheme does is that it requires our regs to be consistent with federal, and the federal regs in turn talk about levels of inspection. And that's actually, I understand, I apologize, it's not in our brief, that's 49 CFR 350.105. And that talks about those levels of inspections that the feds do with the CVSA. And so that's where those levels of inspection come from. And so the Iowa scheme does incorporate all of that, and that's not disputed. And so the lawfulness of a level 2 inspection, the fact that it's a walk around, that you can ask them to do this, I think is fairly encompassed within our scheme.
I do. When a guy signs up, or gal, to be a over-the-road trucker and has a CDL license, is that something they sign up for too? Is it on that document?
The document, I'm sorry, I don't know. But I
Ever acknowledged almost in a contractual setting. Like when we get pulled over in Iowa for drunk driving, we have agreed when we get a driver's license that we will consent, and if we don't, we could lose our license. Is there something like that with a CDL regarding the inspection?
don't know. I will say, so the A1 disposal case gives some policy background on how frequent these inspections are, that these are, Maine to California drivers often, that they understand that being subject to frequent inspections on a federal level, this is a federally set inspection that happens in all 50 states. So they understand that this is something they're subject to across the entire country, and that it's a walk around, and that you're being inspected and the vehicle is being inspected. And so, yeah.
A good argument to make to the legislature. You still have to show obstructing or resisting. That's what the criminal law requires. And what is he doing that was obstructing or resisting? He wasn't resisting. If Officer Smith had a second officer with him to watch from behind, you wouldn't have needed Mr. Burnett at all, right?
Wouldn't have needed him because you're inspecting him too, and you're inspecting his ability to safely operate the vehicle. And so I think a reasonable officer could say, you're up front, hey man, can you turn on the headlights? If he's not sure where they are, if he's fumbling, if he's delayed, I might want to do an alcohol inspection on him. I think an officer could reasonably say that the inspection of the driver includes observing the driver through the encounter, and I think that tells you something about the safety of the driver. And so I think that's reasonable. So to get to obstruction and interference, to me, I think the district court could reasonably find that when he refused to show that he could operate the controls safely, and he refused to show that he could do that safely and control the vehicle that he was driving, right?
What he was asked to do was to help turn the lights on and off so that Officer Smith could go around behind the truck. That's what he was asked to do, right?
That's the first thing he was asked to do. We never got past that because he started refusing.
For that.
Several times to do it so the officer could observe the lights and so he could observe him. And I think that's the point I'm trying to make, is that his performance of it would have satisfied both prongs of what we're looking for in the safety inspection. And refusing to allow yourself to be inspected and refusing to show that you can safely operate the vehicle, I think amounts to putting a hindrance or an obstacle in the path of completing that.
It's the recent decision, I think it came out after the briefing, Webster versus Westlake. The Eighth Circuit denied qualified immunity in that case, where I think it was an investigation of potential It was a welfare check on a girl, and the mother wouldn't let the officers have access, and even that was held not to be even arguable probable cause to support interference with official acts. What's your response? Does the Eighth Circuit get Iowa law wrong there?
I'm not familiar with the case, but based on your summary, I think that this would be more closer to the thing in Parsons, right? Where it was repeated refusal, and not just a single incidence of refusal, but repeated incidents of refusal that amounts to prevention. And again, I think we're asking, like, what is the officer trying to do here? And I think the driver's participation is a material part of what the officer is trying to do and trying to observe. And so declining to show that you can work the systems, I think, is different than just disobeying any random order, because it's part of it, right? We can't decide whether to alcohol test you if you won't show us things. And so I think you performing the controls and showing it, you are actually obstructing when maybe in other situations in a criminal investigative context, it might not necessarily rise to the level of frustrating that lawful intent that the officer has.
I was a stinker, no doubt. And I don't doubt for a moment the guy was a stinker. But in my experience, interference, it's kind of like outrageous conduct in a sense. I mean, there's got to be something more than that. He was a stinker, but he never raised a hand. He never, there's a difference between being a stinker and actually interfering. Let's say, for sake of argument, that we're not persuaded, that I'm not persuaded that there was interference. Then where do you go?
Where we'll go from there is all due care. And I think all due care is probably, it's a really strong case for all due care for a couple of reasons. When this court adopted all due care immunity, it declined to follow Harlow. It declined strict liability. Yeah, sure. Yeah.
Here is trying to extend a Godfrey claim to Article 1, Section 8. And I understand that your argument is, first of all, that we should get rid of all Godfrey claims, and I'd like to hear that, I guess. But before that, if we're going to have a Godfrey claim, and Bivens was a Fourth Amendment case, and Article 1, Section 8 is our Fourth Amendment, why wouldn't it apply here? Why shouldn't we extend this to Article 1, Section 8?
A couple reasons. Our Constitution is materially different. Article 12, Section 1, I think, precludes the claim. And so if your question presumes Godfrey's rights and whether we should just extend it, my issue with Godfrey is that I think there are very few provisions that it wouldn't be extended to. Okay.
Argument in Godfrey, I argued that point, and I got 3 votes, and there were 4 votes for the other side. And
For today. Okay.
Standard is, if this court today does think that Godfrey was improperly decided, is that enough on itself to overrule it? Just that point on the text and the history, or do we have to go further into whether it was unworkable or something along those lines?
In this court's cases, both previously and in recent history, is that the Constitution's a little bit different. You have an obligation to get the Constitution right. And so I think there's the workability standards. Those things play less of a role because I think we could craft a ton of very smart workable policies that are contrary to the Constitution. And so that text has to be paramount. And so I think workability concerns take a back seat here to getting the text right.
Erroneous different than wrongly decided, or is it?
Oh, I don't know that it is, but in the constitutional context, I think wrongly decided is the end of it.
for Godfrey to be overruled below, did you, in the district court?
It's in our motion for summary judgment. I don't have the page in front of me. I think it's in our brief. I cite it's an appendix site in our brief, certainly, where we did say Godfrey was wrongly decided.
I'd like you to respond to Mr. Diaz's point that in this context, where the state has claimed immunity or provided immunity to its officers for false arrest and also claims immunity for itself, that is the kind of situation where we should recognize a constitutional tort because there is no relief for the citizen. What's your response to that?
Two things there. So The one premise is, can there ever be a gap between right and remedy under our Constitution? And I think the answer is yes. I think we have a lot of gaps between right and remedy, things like political question doctrine, things, prudential considerations like standing, all those things preclude constitutional adjudications. So we know that there can be some gap between right and remedy in our Constitution. So then the question becomes, when is that gap desirable and when is that gap undesirable? And I think that's a legislative question. The second prong is I don't agree that, yeah.
Opposing counsel's argument was that maybe there's a due process issue or a Fourth Amendment type issue there. In other words, if a police officer commits some intentional tort, assault, battery, something like that, that currently isn't covered under 669.14.4, that there has to be some remedy, right? That police officers can't assault people, they can't batter people without there being some remedy. And if it's not a constitutional tort, what is it?
Again, though, the question of does there have to be some remedy, what 40 states have that Iowa doesn't is a remedies clause, right? Minnesota has one, that's actually Article 1, Section 8 of Minnesota Constitution. They have a remedies clause for exactly what you're talking about here. And then their constitutional tort action, it's based on text. And so, again, I don't know that it matters what the hypothetical is. To the extent that you're asking whether Article 1, Section 8 would preclude the application of sovereign immunity on a false arrest claim that Mr. Burnett did not bring, that was not barred in this case, that adjudication never happened, I think that's a question for next time. And I want to be clear about that. The state hasn't briefed that. I think it's a really important question. And I want to make sure we have opportunity to do that, but it's not a predicate to revisiting Godfrey. Yeah.
There's an existing remedy or a gap, as you put it. Can we consider the existence of a federal 1983 claim?
I think, but frankly, I don't know how far that goes because that's also an action of Congress that could go away based on congressional intent, right? And so and that's not what Godfrey was based on. Godfrey was a direct claim under the Iowa Constitution, right? And so we're only dealing with the document.
The Godfrey claim for the, when there was a Iowa Civil Rights Act claim. Okay, so there's a Section 1983. Maybe if Congress rescinded it, we'd be, yeah.
That's so I do want to respond to one more of Mr. Diaz's points here, which is that common law torts remedy private interests, but constitutional torts remedy some greater harm. I actually think that's not an accurate statement of how we framed common law actions. I'm looking at the Ackerman v. State case from 2018, and in there, this court extended the common law wrongful discharge cause of action to an employee who did have a contract with her employer. And the reason we did that was because they said the contract remedied the private interests between employee and employer, but the common law cause of action remedied, and I'm going to quote here, the greater harm to society when an employee is punished for acting in accordance with clear public policy. And that tells me the way we've thought about common law causes of action is actually greater than my opposing counsel gives credit for. And so I think the premise that common law causes of actions are remedy between two people, constitutional is greater, I think is inconsistent with how we've conceptualized common law actions in the past. And I don't think that principle holds up. I do want to finish my all due care point because I think that's important. My opposing counsel's formulation of all due care, I think, renders it to kind of an inoperative tautology, right? Their formulation is that the care that's due is to abide by the law, and if you don't abide by the law, you didn't take the care that's due, and that is indistinguishable from merits, right? And so that would just render the immunity a nullity, and I think there's a reason we didn't adopt strict liability, that immunity has to mean something. Here, I think it's really important that Officer Smith had arrested someone for this precise thing previously, and the person was convicted. I think this is not a situation where it was a gray area. He was doing his best to interpret the law. He had the question resolved, right? Can I do this? Yeah, the person was convicted. So this was someone acting in total good faith here. And the all due care immunity, right, it responded to Harlow that sometimes Harlow immunizes bad actors. But here, so we elevate good faith, we elevate reasonableness, and we put a little bit less emphasis on settled law. But here, all those factors, I think, support Officer Smith here. Even if you find that probable cause was lacking, which I don't concede, but even if you do, I think he acted in accordance with his history. A court had said, yes, this is something you can do. He had reasonable grounds to do this. I don't think that video shows any absence of good faith, the presence of bad faith. This is the type of officer that all due care was designed to protect. So to the extent you decline to revisit Godfrey and you reach the all due care issue, I think you should be affirmed. Thank you.
So I think I want to make 4 points, if I can. One, this is the first time I've heard any regulation having been raised in this case. I specifically asked an interrogatory where I said, set forth all of the legal basis. No regulation was ever set forth.
Are they? Those aren't easy to find. Some,
Kind of thing, if you've got something, let me see it. And I asked, and there was never provided, and never provided to the court. Secondly, this concept, and it sort of falls with, well, let me talk about 1983 and the adequacy, Your Honor. The problem with 1983 is the concept that we laid out in Godfrey is that there has to be an adequate remedy at law. In Godfrey, the court said, we're not going to follow Harlow because we've got all kinds of problems with qualified immunity. If you subject the plaintiff to a 1983 claim, what you're really doing is subjecting it to a purported remedy that this court has said is really not adequate. So I don't believe that 1983 would be an appropriate vehicle for, to constitute adequate remedy. I'm sorry?
With Egbert. So there, I think the court says, and correct me if I'm wrong, that there's an adequate remedy for the plaintiff because the offending officer may be subject to disciplinary action and internal investigation, none of which provides a financial benefit to the plaintiff. And the court said that's fine in terms of remedy. So if we were to follow that analysis, wouldn't that indicate 1983 should be sufficient, even if it has some obstacles?
I get it. My guy sits in jail, their guy gets slapped on the wrist, and that becomes the adequate remedy for my guy in jail. That doesn't make any sense. I understand that may be what the court there said. I just don't think we should follow that line of thinking. There has to be an adequate remedy to the person.
Bivens set the standard for private causes of action, constitutional torts, and to the extent that that's true, the Supreme Court has done nothing but retrench Bivens. So if we're to follow Egbert, I mean, unless I'm mistaken, that is what it said, that these administrative remedies are sufficient, right?
Said in Godfrey is that it was well aware of all of the problems that the Supreme Court has had with Bivens since Bivens. So this court was well aware of it and still went forward with the Godfrey claim.
Was that they didn't overrule Bivens, right? I mean, it was consistent with what they've been doing for the last 40 years. Ever since Bivens, Carlson, and Davis versus Passman, there have been no new private rights of action under the U.S. Constitution, right?
Yes.
Do you agree with your opponent that if we think Godfrey was improperly decided, and if we believe that it gave this court a right to create constitutional torts that under the text of our Constitution should be in the legislature, if we come to that conclusion, as did the Godfrey dissent, that it'd be appropriate to overturn Godfrey at this point?
I'm not sure I'm tracking. Well, my position is Godfrey was correctly decided. And if for no other reason than to have a constitution that you cannot enforce offensively is offensive.
Like for the 160 years prior to Godfrey, that's what we had, right?
A lot of times it's context, right? It's who's bringing the claim. Do they have something else? You have to also recognize that 1983 claims are great up until everybody started tinkering with qualified immunity, making that a less available remedy for a plaintiff. So I can't speak for those who lived before me. All I can say is the Godfrey was this court's decision. It was correctly decided, and I don't think there's a good reason to go back and say, we're going to take away somebody's constitutional right to bring a claim and subject them only to a defensive, the ability to use it only defensively. If I can, the last comments I want to make about qualified immunity is this court has said mistake of law is not probable cause, and this court has also said that the all due care defense is to conform to the requirements of the law. If you don't know the law, how can you be conforming to the requirements of the law? So that's what this court has said about that. Yes?
Does the acquittal have in this case? How should we treat that?
Well, I think I've argued that I think the acquittal, given the context in which that case was tried, is probably the equivalent of like a res judicata or a claim preclusion effect, because Officer Smith was the only witness, and he had an opportunity at that point to state what it was that Mr. Burnett did that violated the statute, which of course he didn't. So I think in this context, this particular unique case, I think it's preclusive. But I'm fine if the court thinks that, we don't want to go there and you want to send it back. But I think you send it back with a finding that there was a violation of the Constitution here.
Can you explain that to me a little bit? So he's acquitted. How does that make a determination on probable cause, which is a lesser standard?
Well, I think maybe we're talking about two different things. I mean, the acquittal in this case, I think, has preclusive effect, because the only real issue there was whether or not he was required to assist in this case. So if this court concludes, and you don't have to go there, and that's kind of why I say you don't have to necessarily go there and say that's the basis upon which we're going to find as a matter of law that I'm way beyond, Your Honor.
I just want to make sure I'm understanding what you're saying. The probable cause determination is whether there was probable cause to believe there was a violation of the statute, not whether he actually violated the statute. The legal determination that he was not guilty is a different question with a different burden of proof.
Under normal circumstances, yes. I think in this case, the uniqueness of the way this case came down, I think it's the same. Effectively, it's the same. Thank you.
Burnett versus Philip Smith and State of Iowa is hereby submitted. And I wanted to take this opportunity to thank Adam Ziener. We were backstage, but we appreciate your comments made on behalf of the Polk County Bar Association. We also appreciate the Polk County Bar Association has put together some goodies down on second floor. You can take the elevator down, or the stairwell, I believe, is open to the public as well. To the second floor, we have something called the light court, and we'll go back and throw our robes in the closet, and we'd love to see you guys there. So thank you for being here. And we have oral arguments again tomorrow and Wednesday. So for tonight, court is adjourned.
Hear ye, hear ye. The Honorable Supreme Court of the State of Iowa is now adjourned.